Hello, this is Alexander Cross, attorney here in the San Francisco Bay Area. If you've been accused of having committed a crime here in the San Francisco Bay Area, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. Today I'm going to respond to a question that we received here in our YouTube channel, Alex Cross. Let's see, back in 2005, I was accused and convicted of domestic violence. What will happen with my new case? I was charged with a similar offense. Well, if you were recently charged with a new domestic violence offense, that's not a good thing, especially with you having a prior in 2005 for a similar offense. But the good thing is that because that prior is more than 10 years old, generally speaking, it will not be used against you in court. Unless your prior was a strike prior, it probably will not be used against you if it's more than 10 years old. Now, in this situation, just like any other domestic violence case, the first question that any criminal attorney would have is, well, what's the extent of the damage? I mean, if the victim suffered injury, visible injury, or a traumatic condition, well, then we're talking about a felony, which would be a violation of Penal Code Section 273.5, which carries up to 4 years in state prison. Now, if we're talking about a spit, a push, something like that, well, then that would be a misdemeanor under Penal Code Section 243, parentheses E, parentheses 1, which carries up to 1 year in the county jail. Regardless, either one of those charges are considered crimes of moral turpitude, which means that if you're not a U.S. citizen, a conviction of either one of those offenses could result in deportation, exclusion from the United States, and denial of naturalization. But you have to understand that here in San Francisco Bay Area, domestic violence is prosecuted very, very vigorously, and any kind of harmful or offensive touching could result in these charges. Now, I want to focus a little bit on the misdemeanor version of domestic violence, and the reason is because some people have this idea that they have to punch their spouse or punch their girlfriend or ex-girlfriend or somebody with whom they've had relations with. No. Simply, any kind of offensive touching would be the basis for a domestic violence charge. For instance, and I always tell this to clients, if you're having a verbal argument, with your spouse, ex-spouse, girlfriend, ex-girlfriend, person with whom you've had sex with, do not physically touch the other person in any way. And I'm not saying this euphemistically. No, I mean literally. Do not touch the other person in any way, shape, or form if you're having a verbal argument. The reason is because any touch can be interpreted as an offensive touching, and that could be the basis to charge you with a crime that will make it very, very difficult for you to get a job in the future. So please avoid this problem. But if you have been accused of having committed such an offense, be sure to give us a call. And if you'd like to learn more about criminal cases here in the San Francisco Bay Area, be sure to subscribe to our YouTube channel, Alex Cross. And if you have a problem with the law, be sure to give us a call at 1-800-862-7677. We'll see you shortly.